Okay, y'all. Real deal. We are here for the sentencing. Jonathan Quiles, he won't come on till 10. So what me and the real deal is going to do is chat. Okay, we just gonna chicken the chat until it come on. Thank you. So when I'm waiting on the girls to do in the gents is to come over to this channel, and we just going to chat until it starts. Share and subscribe. So what I need to do is, y'all, I need to go and show something. We got to look at something. Okay, we'll just chat like we was doing then. Hey, Jackie. They'll be in a minute. They going to get some coffee and stuff. Johnathan had on a green suit, yeah, the other day. Oh, y'all said 10 o'clock. It's bad. Maybe I need to put it on something. Maybe we can go back and revisit something. I could put it on something like that until the trial come on. Unless we'll just sit here and just talk. I guess we. I'm still trying to find out why them. I'm still trying to find out why them dogs didn't. I'm trying to find out why them dogs did not find. Yeah, we back now. I'm trying to find out why them dogs. I'm about to put it on the one. We're gonna look at. We're gonna look at. Yeah, dude, let us know when it's on, because I'm about to let us see. Uh-huh. You know what? I want to see the one with the wait a minute.
Undercover informants and a brother.
I'm trying to find the one with the detective dog. What they call abracadabra dog. I want to see that. I want to see that trial again.
Current informant were among those testifying at a high-profile death penalty trial today.
Oh. Trying to find the abracadabra dog. Hold on, y'all. Okay. So, hold on. I don't know what day it was.
Critics are calling The Creator the best film of the year.
Hold up, y'all. I'm trying to find the one. Let me see if this is it. Hold on. With the detective dog. Let me see. That's who I'm looking for.
Prosecution is to prove that Johnathan Quiles killed Diana Sawyer even though her body was never found. Snapchat messages between Quiles and Sawyer were read out loud in court today. Those messages reveal much more about their relationship.
I love kissing you. Just after I found out about the boy, it turned me off about a lot of things.
Detective Billy Abbott with the Jacksonville Sheriff's Office read those Snapchat messages from Quiles to Sawyer to the courtroom Tuesday.
I'll stay as far away as I can and keep you happy, but not you, Miss Real Friendly. But like I said, it's all good. I'll get over it all.
We spoke with Belkis Plata, a lawyer with Jacksonville law firm Plata Shot Law, about the case. She says much of the evidence is circumstantial since Ayana's body was never found. What is the burden of proof that the prosecution has right now to prove that Quiles was in fact the murderer?
So the state, they carry the burden solely, and it's proven beyond the exclusion of every reasonable doubt. So they have a very high burden that they have to overcome. And for people, when you don't have a body, it's difficult for them to convict because they just don't know.
An informant and Quiles' brother are expected to testify in the coming days. Plata says it's up to the defense to poke holes in their testimony.
So I'm very interested to see about this informant. If in fact he wore a wire and Quiles admitted to certain things, I think that could be a huge turning point for the state.
Plata thinks the testimony from Quiles' brother can potentially sway jurors if he testifies.
I think the jury will really hold on to what his brother is saying, because I can only imagine how difficult it must be for a brother to be called to testify against his own brother. But because of the nature of these charges, I think it will hold a lot of weight for the jurors.
It's not clear what the weight of those Snapchat messages will hold just yet. The reading of those messages were cut short Tuesday with the plan to pick up where they left off Wednesday morning. We're about to go live. At the end of court today, the judge told the jury to expect the trial to go into the...
I want to go back here.
Husband, Clifford Ware. All right. And how long have you lived there?
About,
And does that mean you were in Columbus, Georgia in 2018?
yes,
Who
It's
is
on.
IS, Ayanna Sawyer, to you?
my granddaughter.
And is that by your son?
Let me turn.
Yes.
And is your son's?
The biggest burden for
This ain't it. I'm on the wrong one. Is it this they on?
You ever get tired of being at the bottom of the top? What's standing in our way?
Hold up.
First, we would just put an objection on there. We would, based on what they're telling us now, obviously there's some different things that obviously can be overcome. Just for purposes of the record, just want to put all on the record as that issue. That's where we are with respect to this.
Is this it right now? This I'm on the right one or do? I'm on the right one.
We had a little bit of email communication over the weekend. The state of Florida is abandoning the aggravating
Is this
factor.
it?
Engage in the commission of aggravating factor. That's what was on the record Friday, the one about being engaged in the commission of sexual battery. We're doing that because we believe the aggravating factor, the first one, the prior violent felony, as to count one, we can argue counts 2 and 3 apply as to count 2, counts 1 and 3.
Yeah, do it. Is this it? Because I don't see it.
Cleaner takes away from those 2 aggravating factors merging, then requiring merging instruction. For multiple purposes, we're abandoning the engage in the commission of aggravating factor.
No, this day one. Hold on. Let me find my track. Find my track. Because this not it. This it?
One of the things the court did ask us was which aggravating factors apply to which count. All apply to counts 1 and 2, both first degree murders, with the, we believe, the exception of HAC. We are not going to argue HAC to the unborn child. Our argument is strangulation.
What they got?
I'm out. Yes, sir. Is right.
Yes, sir.
So HAC aggravated factor number 3. This only applies count 1. Correct?
Yes, sir. Yes, sir. That's correct.
What I'm telling the jury is, I'm going to tell the jury, here's all the aggravated factors alleged by the state. Then I'm also telling them, following aggravated factors apply to counts 1 and 2 unless otherwise noted.
That's correct.
So, for example, HAC would be the first one where I tell them first degree murder was especially heinous, atrocious, or cruel. This only applies to count 1. That's what I'll tell the jury. The verdict form will, of course, reflect that. So give me a second.
Absolutely.
So, on count 2 verdict form, I'm taking out the heinous, atrocious, cruel. Correct.
The state agrees. Yes, sir.
Okay, so you can go.
Yes, sir. And then, so just for the record, so the first aggravating factor, the previously convicted of another felony involving use with threat of violence and personal arguments to both. The second one, the committed.
This might not be it.
Preventing lawful arrest, we're going to argue as to both. As we just said, HAC will be only as to count 1. The fourth, TCP, full calculated and premeditated aggravating factor, we're going to be arguing for both, and then have intentions to kill both. As the fifth one, the victim of the capital felony was a person less than 12. We are only arguing that for the second count, obviously, the child. And lastly, we were arguing for both capital felony that was committed.
And it can be prevented.
Someone who's particularly vulnerable and is in a position of familial or custodial authority of the victim, we argue that. That's the vote. So ultimately, in sum, Your Honor, the third HAC and the fifth victim under 12 only apply to one respective victim. HAC only to the IS and victim under 12 only to the child.
So in total, it looks like there's going to be 5 aggravating factors alleged as to each victim.
That's correct.
Okay.
There's 6 total, but yes, there are 5 as to each. That's absolutely correct.
So the last one being vulnerable due to familiar or custodial relationship. As of Friday, you weren't sure that was going to both counts. Now the state is alleging them for both counts.
We have thought about it, Your Honor, factually. Witness believed assaulting the wire that was his child, so he's caring for him.
He was just checking Michelle out.
He's also custodial authority over his unborn child, as he thought. So yes, sir.
Okay. So in the final instructions, there's no need for me to tell the jury anything about emerging aggravating factors, correct?
That's why yes, sir. We are not asking for none of these that are left merge. There's no need to now define felony murder or anything of that nature. So yes, sir, we believe it simplifies things, and the court has that correct.
Anything else you wanted to address?
Hold on. I think the court wanted to talk about contemporaneous versus previous language.
Yeah. The reason why I included the contemporaneous language is that in Standard Instruction 7.10, I'm reading straight from it, defendant was previously, in brackets, or contemporaneously convicted of another capital felony, a felony involving the use or threat of the use of violence to another person. In this case, he was contemporaneously convicted of the first-degree murder. It's not a prior sexual battery conviction that the state's relied upon. That's why I use that language. I understand how, if it's previous, it's certainly similar to the first aggravating factor under the statute regarding the prior conviction.
Yes, sir.
And so that's why I put contemporaneously, because it's provided in the standard instructions.
Yes, sir. Our only concern was that the actual statute itself doesn't say contemporaneously. However,
well, as of today, he's been previously convicted of it now.
yes, and that was going to be our argument that you convicted on Friday of those other 2 counts. So if the court wants to give that, I would want.
Hold on a second. So you want previously?
The state would ask to do previously or contemporaneously, so long as the defendant agrees it's not object. That's so.
Defense position. The statute says previously. I'd rather stick to what the statute says. I'm not sure why the standard instruction includes language the statute does not include.
Well, and I was going to stick with the statute, Judge.
Okay. I'll just put was previously.
And would the court make sure the defendant himself agrees to that?
Agrees to the language in the statute?
Yes, sir. Because of the discussion we just put on the record regarding the alternative, he's not requesting consent. If he does, we would say the previously or contemporaneously, but he's fine with or previously the state is obviously.
It's a bit of a legal issue. I'm not sure he has the legal knowledge to understand that.
That's.
Or understand the distinction of the statute.
He's fine with leaving it with just previously.
Yeah, he's smiling.
I'm changing all the instructions and the verse forms.
He like Michelle.
But your argument's going to be that the prior conviction is the sexual battery.
Well, no, sir. Our argument is we have to count 1. They found him guilty of counts 2 and 3. So counts 2 and 3 sort of play into count 1.
Understood.
And then count 2, we're going to argue 1 and 3.
So you can argue the other murder as a prior felony under the aggravating factor?
Yes, sir, because they convicted him on Friday.
Okay. Makes you wonder why you wanted to proceed. Well, never mind. I'm not going to get to that.
He like Michelle.
Changes on the
She a pretty lady.
verdict forms and the standard instructions for both preliminary instructions and
charging instructions, which I will send a copy to everyone as well once we finalize all this.
I need to change the language for the last aggravating factor. What I can do is the victim's name is going to be actually in the instruction regarding vulnerability due to their familiar custodial authority. What I may do is just have it language for IS and say this applies to count 1, and then have another paragraph that says that for the unborn child that this applies to count 2.
Yes, sir. State your reason.
Judge, just for purposes of the record, I understand how the state is proceeding on the last aggravator, the familial. We would object to it as Mr. Quiles was not in a familial position over IS at the time. He's not her father. He's not a caretaker or caregiver. I mean, she did go over to his residence, but he was not in a familial capacity.
Well, the statute says familial or custodial.
Just over defenses of objection.
Understood. He was also found guilty of sexual battery in a familiar or custodial relationship as well by a jury. So the jury can make that determination if they believe it's familiar or custodial or not for either IS in count 1 or the unborn child of IS in count 2. So I'll leave it up to the jury. But if you need to make a motion at some other time during the pendency of phase 2, obviously you're more than welcome to make those motions or arguments throughout the pendency of the second phase.
Yes, sir, Your Honor. We just, for purposes of the record, we want the objection noted for.
Okay, and it hasn't gone to the jury yet, too. So,
right.
Other than the defense witnesses, any other issues from the state's perspective?
Yes, so there's one more, just for the record, maybe before we decide to inquire. The defense did let us inquire of Dr. Rohr, R-O-H-R-E-R, on Friday. We spent very quick evidence with her in this very courtroom and sort of gleaned from her what she would be testifying about. You're not asking for any rebuttal with respect to what we expect to say. However, talking with her, she did. I asked her to sort of, in her testing, pull out some personality traits that she found in the defendant. She used terms like egotistical, self-centered, narcissistic, and some things that I will listen across. I just want to make sure that I'm sure the defense made their own decision about whether to call her. I believe they are. So at the moment, they do. I just want to make sure the record's clear. We are listening to that. And that
Is this information that was in her report or things that you gleaned from her?
Yes,
well, hold on a second. Let me finish the question. Just for the transcript, are these issues or information that was gleaned in her written report or things that you got from her via deposition or through interview of her?
You know what, we were asking her to define terms in her report and asking her, sort of summarizing her opinion that she wrote in her report, what types of conclusions that she determined regarding personality traits. She started offering them. So while she doesn't write every single one of those, I think it's clear in the report, but does eventually define antisocial personality disorder. As we were delving into that, that's when she started describing what personality testing showed. So our position is across, we're going to elicit that. Just want to make sure that the defendant himself is one, soliciting that due to the fact that they're calling and they're trying to make their own decision. It's something we want to talk about.
Okay.
We are aware, Judge.
Understood. So nothing else from the state perspective, anything from the defense perspective?
The last thing, judges, I think the court may already give 2 victim impact statements. We are intending on calling SF.
Not the mom. Okay. For whatever reason, I just wanted to clarify because as of Friday, it seems.
Yes, sir. That's the 2. So we did send that very late last night. We apologize. It was probably around the 10 o'clock hour. We actually had a victim advocate staff member working with the family trying to get them in. We finally got those done. We sent those last night. We're told this morning there's some objections. What I've asked before they're read is to send to
be clear, Dan, we only received one. There's only one on your attachment.
Were both documents in the same attachment potentially?
No, Judge.
No, one is clearly just SS.
So the record's clear on that, and one's about 2.5 pages, and the other one's from SS, double spaced, about 4 pages.
The one from SS we have, the one from,
All it takes is,
we did not get that one, Judge.
Thank you, Mary. Thank
Did you
y'all.
testify at trial? That's ID's mom? Stepmom, that's right.
Yes, sir, Your Honor.
Okay. I'm supposed to have a jury in front of us in about 20 minutes. How we looking?
Good morning, Shelley.
Judge Weed. I'm looking through my email, and just for the record, we did receive an email from Mr. Skinner at 10:02 p.m. last night to Bob and I saying here is one, and it attached the one that we have had a chance to review and do have some objections to. I'm looking now, I'm looking in my spam. I do not have another email from him with this one, so having just received that, Judge, I would like the chance to review that. Obviously, it's going to take longer than I think 20 minutes to line item that.
If that didn't go to our mistake, I will send that, giving them a hard copy, I'll go ahead. Copy of it.
Who are the 8 people from New York you're trying to call off this list? 8 to 9, however it may be.
Yes, Judge, and just to confirm, I did speak with Paulette, who is the defendant's mother, or aunt, but in a mom type of position. She did email me this morning and let me know those who could for sure be present. As you're aware, on Friday when we found out about the Zoom, I just asked her to give me the list of people she thought would be appearing so that I could provide that to the state. I did do that, but as far as who will
Can I state something? I also want to make it clear. I didn't know it was not it. I didn't know it would be an issue. I didn't know who the defense was calling in the penalty phase if the trial got that far. I know there was a witness list. I didn't really inquire beyond that. I didn't know people from out of state wanted to be present but could not be present, whether it be logistical or financial reasons. I had no knowledge of that until Friday. The state didn't object to Zoom. I made it happen with the courthouse information technology people. I didn't know it was an issue. And if it became an issue, I can't imagine the state would have objected. They didn't object Friday. But now that's why we're in the position we're in right now.
Judge, and I had no intention of making it seem as if it was the court's fault by any means.
Sure. I just wanted to make sure that was clear for the transcript. If the case it's an issue on the back end, that it was not an issue that I knew that needed to be addressed until Friday, until I inquired of Mr. Quiles.
Understood, Judge, and there may just have been some miscommunication there, because when we talked about using Zoom throughout the trial, the court had made it clear to those who had been appearing via Zoom throughout the pre-trial hearings that Zoom would not be available, and I think that's when we kind of said, okay, if Zoom is not available, then we move.
It was not available.
Right.
It's not available for members of the public to come watch the proceeding. Obviously, we had issues now with people on Zoom making sign language to your client. I was not going to allow Zoom to be present during the course of a trial. It's a public courtroom. People can come watch trial as much as they want. They can probably go watch a live stream if they want. But I was not going to have Zoom be present for members of the public to come watch the trial. That's not appropriate. And nor has the Supreme Court ever said that's appropriate. They've allowed it for pretrial proceedings, attorneys to appear. Never has it been made available. And I think I've been very kind's not the right word, but I've allowed Zoom at a lot of proceedings, particularly in this case, for victim's family too, defendant's family to come present when they normally would not be able to attend certain proceedings. And I understand that. But when it comes to evidentiary hearings, when I got a job to do for a trial, Zoom was never going to be on the table. Now, for people to attend a trial, to testify, that's a whole different analysis, if you ask me. But understood. But nonetheless, who are the 8 or 9 people you want to call from New York?
Yes, Judge. So I sent the list to the clerk a little earlier. From that list, my understanding is that today It will be Paulette Burette, who will be testifying in person, KB, Kenneth Berry on that list, in person, Curtis Hale in person, Ishana Pugh in person, and Karen Gaines in person. Or her name might be Karen Gaines McMillan, if I'm not mistaken.
Okay.
And then on Zoom, Judge, they have tried to limit those to just 3 of the 8 that were listed to accommodate what the state's request was, as far as not wanting
He went and
more
got his cousin.
than that.
I mean, I haven't ruled on that. They've made an objection. I don't know what these people are going to say. You guys work it out on your own end of who you want to call and not call. That's fine. But I have not. I've chosen not to get involved on purpose because I don't know what these people are going to say.
Understood, Judge. As far as what 3 that would be via Zoom at the moment, if there's no objection, would be Vanessa Bracity. I may be saying that wrong, but it is spelled Bracety. I'm sorry. Let me get the exact spelling for the record. Or was it provided to you? Okay, great. Destiny Quiles and Joseph Quiles.
And those 3 are in New York, I'm assuming.
Those 3 are all in New York, Judge, and they would be testifying on Zoom individually.
And they're available this afternoon.
They're available whenever we need them, Judge. I did tell them to make themselves available anytime.
This
after 10. I didn't give them an
afternoon.
exact time. I said I would let them know as we progressed exactly what time they would need to be on. I did also let them know that they would not be sitting on Zoom all day, that we would open it when it was time for their testimony, so they're aware of that. And there was one other thing, Judge.
And Dr. Rohr's the only one not on this list, I'm assuming.
And Dr. Rohr, I apologize.
Yeah.
The only other thing, Judge, is that they... Sure. And just for the record, the state would like us to put their relation to Mr. Quiles. So Vanessa Bracety is a long-term family friend who's like a sister type of, they grew up together type of situation.
Lord.
Destiny Quiles is a cousin. Niece, I apologize, a niece. And then Joseph Quiles is his brother. And I believe they know the relation of the people who are in person because they've asked that.
Okay. And so those are the 3 you guys are calling this afternoon upon your own agreement after talking to the state about the number of people from New York.
If there is no objection from the state, we would like to call those 3 out of the 8 of the names that we provided.
The state not objecting with respect to 3 when it was just represented to us over the weekend that they were going to call 8 to say a very, very similar testimony, which we felt was cumulative. If they're only calling 3, there is no objection by the state so long as the defendant is satisfied with who the defense is calling.
And Judge, just to be clear as well, I did speak to them this weekend about having them appear in a way that they could express their support, but then not necessarily all testify to the same thing. And what they have agreed to do is to state their name, who they're speaking on behalf of, because some of them are like, I'm speaking on behalf of my sister, my mother, and so as well, who would be here and present and say the same thing that I'm saying right now. We agreed that that would be the way we would handle it instead of calling each and every one of those witnesses, just to avoid that very objection that we, of course, would not try to present duplicates of this exact same information or cumulative type of information. So as long as that's not objectionable, we would plan to proceed in that fashion. We have spoken with...
I'm sorry, my fault. Please continue.
We have spoken with Mr. Quiles about presenting these additional witnesses. He did want some of his family that lived and resided in New York to be able to appear. And so at this point in time, if there's no objection, then we would proceed in that manner.
And those are the 3 that the people in New York that he mentioned 2 to 3 on Friday. Obviously that number grew. Now it's shrunk to 3. And then those 3 are testifying on behalf of other people as well. That's to his satisfaction. That's what he wanted you guys to do.
Yes, Your Honor, I think that would satisfy. And frankly, Judge, those are the people who are available. And so I think there may have been one other person he wanted, but that person is not available to do it. So they plan to speak on behalf of the person that he planned to or asked us to get.
Okay. Mr. Quiles, can you raise your right hand? Do you swear, affirm, tell the truth, the whole truth, nothing but the truth? All right, sir, you can put your hand down. You've heard the conversation this morning regarding these witnesses, the 5 to 6 people in person or so. And that includes the expert, Dr. Rohr, and then the people on Zoom. Is that with your satisfaction and agreement?
Sure.
Okay, those are the people that you want that testify on your behalf, and those people are going to be testifying on behalf of other people as well from your family.
Correct.
Is that what you want? And your attorneys have talked to you all about this? They've answered all your questions? Anything else? Anything else from the defense on this issue?
As far as the witnesses, Judge, no.
Okay. All right. Thank you, sir. So then the only outstanding issue this time is the victim impact statements for review? Okay, so obviously I have a jury arriving here any minute. What do you want me to tell them?
Judge, as far as the victim impact statements, Mr. Davis is going to try to review and line item the one. I'm going to try to do the other right now. We're going to work as quickly as we possibly can so that we can be ready to go. If there's no objection, we'll provide that to the state. If they're okay with striking whatever we have, then we can move forward. If there's going to be some additional argument that needs to be made, then I think we should bring that to your attention after we've had a chance to look at it.
How long do you need to review everything?
We've already looked at the one, so I think he's just going to mark what we discussed already. This is like 2.5 pages, so I'm sure I can read and start marking in the next 10 minutes, 15 minutes max.
Okay. How about I come back? I'll come back out around 10 o'clock, which is what I told the jury anyways. At that point, maybe we'll have at least one statement should be, you would think, close to being completed, and then we'll see where we're at in the other one.
Yes, Judge.
I just want to let the jury have some idea of what we're dealing with. That way they're not sitting in a room waiting for us. Just so you guys know, my office made contact with the 4 alternates. They were told to be present. Actual conversation and verbal contact was made with all 4 of them, and they told my office that they would be here by 10 o'clock for the proceeding. So let's come back out at 10 o'clock. We'll see where we're at. And we'll go from there. We can deal with the final instructions and verdict forms as we get there, although I probably will go ahead and share everything with you guys. That way you have everything. The verdict form should be rather complete. It has the aggravators, the states listed. You guys can look at the final instructions. It has all the mitigators the defense is relying upon. And you can take a look at that. You weren't here when I told Mr. Davis, Miss Michelle, but I listed the mitigating circumstances as it was phrased in the pleading. I didn't really change anything up. Some of them seem to overlap a little bit with one another. Some of them have like the same beginning, but kind of go in a different direction. So I put it as is. I didn't want to mess with anything. If you guys want to combine them or separate them out, I'll leave that up to your discretion and how you guys want to proceed in that regard. Some of them mentioned, he was 15 when he dropped out of school or something and had a child, and they kind of all talk about the same thing, but then go on a different branch off that tree. And that may be on purpose. I'm just letting you know what I did so you guys can take a look at it. Okay, so we'll be in recess till 10 o'clock.
Yeah, I heard that. Recess, yeah. Y'all know what? This gonna be going on while I'm at work. Cause he talking about this evening. And it's 10 o'clock. When he come back at 10. They doing too much. And I ain't got no TV out there. He told dude, don't he? This is the most breakingest man. He must be in love. He take more breaks. He look like he trying to keep up with somebody. He take more breaks than any judge I know. Jesus. Johnathan on when got his all his partners. Johnathan when got the best friend of the family. You know when got everybody, boy. Johnathan when got him some witness on y'all. You know when got the best friend. Gone, Johnathan when got him some peoples. Them folks ain't coming all the way down there from New York just and he done been found guilty. They sitting at home watching this thing. And with the state, that lady must not be there, y'all. I heard the man, but I ain't hear the lady. The prosecutor for the state, that woman. What y'all thinking about? What y'all thinking about? Y'all thinking, man. What y'all thinking about? I know y'all trying to find it. Well, we ain't got that long, cause it's 9:50. Man, I'm sleepy too. Might have to move the phone away, the laptop away from me. And he been smiling at something. Johnathan know when he got hit. Who he got? His witness is I don't know why they keep calling his brother to the stand, cause his brother ain't gonna change. I know. Where you? Oh, you at work, right, Linda? You and Michelle probably at work. Well, this thing ain't gonna be going on all day. Look, Linda, you didn't send me your I need your email me. You need to email me. Big dog, I didn't get your email address either. Your email didn't come through. Only one I got is Michelle. I needed y'all email. You at work too? I know. Let y'all. I'll be gone. I'll be gone. See, that's what I do. See, I'm so used to coming home, take my nap, and then go back to work. But since I've been doing this trial, I've been come home doing the trial, and that's why I be sleeping. Wow, y'all at work. Y'all, I done got so happy. I thought I was gonna get my Social Security on my birthday. Shoot, they don't took the age up one more time. They shouldn't do that. They gonna keep taking the age up. They tell me I ain't got for 38 hours. I supposed to have 40 hours. I'm gonna check on them folks. Dude, I'm sleeping. I don't ate them noodles too. At the dot in the middle. Good morning. What is Linda? Linda, email me while I'm on here. But it's about to be a long situation right here. You said yeah. What you? I thought you can get a for when you start work. They said my email is in my go to my channel and look in about, and then pull my email down. Go on my channel and look in about and pull my email down. Go on about and then look for it. What you were saying, Dula? I thought you can get it at the age they said for you when you start working. See, it's supposed to go by your age and your hours. It's supposed to be 40 hours, and I don't understand why I don't have 40 hours. Now I should have 40 hours now, but I'm gonna see how that goes. Cause I want to go and start getting mine. Cause every time I go try to get it, they keep taking the age up. Shoot. Need my money before I go. You have to watch them people. I'm gonna call them too. I ain't gonna call them. I'm gonna go in and talk to someone. They sure do. Sure. Now you know what? That's the yeah, the state need to talk in that man who been for the defense, he need to talk in the mic. That man in the wheelchair don't be talking loud in that mic either, because I can't hardly hear him. And the state act like they talking a long way. I can hear the lady, but I can't hear that man. That's right. I want to spend my money while I'm alive. So when I turn when I turn 55, I want my money. They keep taking it up. They said I don't have for 38 hours. They just sent me my note. I can start getting my Medicare. And that's what I'm gonna get too, because I need some glasses. I need some glasses bad, y'all. Well, they need to put that mic down there on him. Okay, go up there. Okay, you see about Linda? You see where it says about? Do you see about? Open. Okay, when you go to scroll down, it's gonna say. Let me put it. Let me show you. Now, cause they can ready to come on in a minute. Scroll down. I just had a class on this. Yeah. Scroll down. Just scroll down. It's gonna say business. Linda. Go to business. It's gonna say business and open it up. It's in there. Okay, you can't worry about it. Child, I don't care. They better come on, because I'm be asleep. And those who complain about me going to sleep, not y'all, but them other folks, I ain't stung y'all, because I get up there, I leave out here at 5 o'clock in the morning. And it's taking them too long. This one lady, I can understand she got it. She working everything. I understand what y'all saying. But child, if you don't go somewhere and take a hike, go run some track. They need to go. They don't got slow. He said 9:59. Linda, open it up. Talk to me while you doing it. Let me do it like this. Hold on. Let me help you out right quick. Oh man. I need to hold on, what time they supposed to come? AT&T. What do I do with the paper? Okay, let me see what time they supposed to come. AT&T, yes, sir. Okay, let me call these folks. Call them when I get to work. You said London. Y'all don't be looking. Mm-mm. I thought he said 10 o'clock. Well, these folks, these folks, but I could have been taking now. I thought he said 10 o'clock, y'all. Yeah, what y'all think gonna happen? What y'all think gonna go down? What's going on? What's going on? Something ain't right about that courtroom. Florida, some other state of Florida court. Florida do what they want to do. They don't take it. They're like me. They ain't taking stuff serious. Cause I'm still kind of confused what's going on in the courtroom because the way they talking like 1 minute I think they trying to do everything before the jury come out, but I don't know how that works. I don't know. I'm penny. Y'all, did he say 10? Did he say 10? Or did he say 10? Oh man, come on, Judge. I thought he said 10 too. I don't know what these people doing, y'all. Oh, there you go. That's somebody trying to walk right there. They need to come on. Let me be patient. They need to come on. I'm trying to hold my ass open. Shoot. He did that. I mean, he need to practice. They just walking. Trying. I'm gonna look. I believe they need to come on. Mm-mm. Look at him, late. Jud be looking like he wanna kung fu somebody.
Let's go on the record. 19 CF 7518, State v. Johnathan Quiles. You have counsel of the state defense. Mr. Quiles present. I do have all 16 members of the jury accounted for. How much time do we need?
Man.
We were actually discussing it with the state as far as doing some of the redactions. We were going over.
Give me a time so I can let the jury know, because they're waiting on us at this point. And I think my feelings about having them wait on us is
You the
quite absurd at this
judge.
point.
I think 5 minutes would accomplish what we're doing.
I was going to say between the two, give us that.
Can you let the jury know 10:30, please?
10:30.
Yes. If they want to walk around,
10:30.
that's fine as well. Just be back outside here that we can start at 10:30. I'll see you guys then.
He a mess, y'all. I can't deal with this. $10:30. I mean, he ran out of there like he ready to get on his phone. It's 10:07. That's Florida for you. Judge got to be happy with waiting because he the one, the judge run that courtroom, y'all. If they had a serious judge, they'll be on, man, please. They having their way. Ain't nowhere in the world. You have to have your stuff together when you come in that courtroom. You think that what it is? He talking about it's 10:07. Man, please. See, okay, so I get that what's going on. She keep on worrying about Michelle. Michelle. No. Michelle supposed to have been got her customers together. Michelle supposed to been got her folks together. She ain't even got her people together. Them folks think on them folks, man. He probably just called them people. And the state, they ain't gonna want them to. I wouldn't even do it. He tell me, I'm about to take them. Yeah. Y'all smash that like button. Cause I don't see, but on my side, I see this don't make no sense. Y'all know it's 10:09, right? I would take me a nap. That's what I'm saying. They ain't taking it serious. John's over there Googling her. It's terrible. Oh Lord, it's killing me. This is Let me put it on something so we can watch it then. Somebody let me know when to come on, about to put it on something where we can watch and see what they're gonna. He said that they're gonna bring I'm about to put it on Johnathan brother, y'all. You don't like Michelle? You sure don't. You don't even know Michelle. Ooh, Lord. You don't even know that woman. Let's see. I want to put it on his brother. Let me hold on, y'all. Let me put it up. Johnathan brother testify. Johnathan. Let's see. Johnathan brother. I'm gonna put it back on Johnathan brother. I want to go to his testimony again. I'm gonna cut. Hold on, y'all. I'm trying to put it on. Somebody got to be the time. I hope I be home 12:30 come, 10:30 come.
Older, I became more settled, and he became more settled. We reunited and definitely spent a lot more time together. Well, mostly through phone in Texas. Yeah.
All right, that's where I was going next. As you got closer, did you generally communicate via electronic devices?
Yes.
Did you get to see him often?
Not often.
What is the age difference between the two of you?
2 years.
Is he older or younger than you?
Younger.
Now, directing your attention back to the latter part of 2018, would you describe your relationship with your brother, the defendant, as close at that time?
Yes.
Were you talking routinely?
Yes.
Were you texting with each other routinely?
Yes.
If the records show you and your brother talked and or texted some 200 plus times on your devices in December, would you agree with that?
Yes.
Would you consider yourself close as brothers could be in December?
Yes.
Of 2018?
Yes.
Would you say you spoke almost every single day?
Just about, yes, every day.
Did he share with you any details about his job at Ace Pick-A-Part at that time?
Yes.
Did he just give you sort of a description of what he did for a living there?
Yes, but he transitioned from multiple jobs, so we always talk about how fast he would climb up the ranks in the job. So, yeah.
At different jobs?
At different jobs.
Did he ever show any video of himself on Facebook or anything like that with you, with him while working at Ace Pick-A-Part?
No, not on social media. We would FaceTime.
All right, even on FaceTime?
Yeah, we would FaceTime while he's like doing his duties at the job.
Did you guys engage communication during this the FaceTime?
Yeah, we can say that, yeah.
All right. Now, sir, are you good with dates?
Depends, yeah.
All right.
I want to direct your attention back to December 19, 2018, leading over to December 20 of 2018. Do you recall, just sitting here now, what day you spoke with your brother about what we're here to testify now about?
I remember speaking to him in that time
day?
frame. Which day? Not so much, but I know between those two days, yes.
All right. If your phone records that this jury has seen reflects that you either called him or he called you on 4 occasions on December 20, 2018, would you agree with that?
Yes, I would agree with that.
Now, in December 19, 2018, or December 20, 2018, were you in New York City at that time?
Yes.
When you had these conversations with your brother, were you at work or were you at home or elsewhere?
I was at home at the time.
On December 20, 2018, when the first call was made, best you could recall, who called whom?
I don't recall who called who.
Fair enough. Did you first speak with him on that particular day? And if so, will you first describe his demeanor, how he was acting on the phone?
When we spoke, his after normal greetings, his demeanor was a little off. It was kind of like he was nervous or a little panicky about something.
All right. Have you heard your brother sound panicky to you on previous occasions?
No.
Did this surprise you how he was acting?
Yeah, always very confident.
Did he appear to be concerned when he was talking to you?
Yeah, more of a concern, yeah.
Was the tone of his voice different?
Yes.
Was he making sense, or was he more talking to you in a rambling manner?
It was more, I wouldn't say rambling. It was more like, I need to do something. There's something I need to do.
All right, we'll talk about what he said in a moment. Is there anything else that you could describe about his demeanor or how he was sounding on your phone calls?
No, just he was worried, just concerned, yeah. That's it.
Worried and concerned?
Yeah.
All right. Now, would you now explain to the jury what did he first start telling you about that took you by surprise, sir?
The first initial conversation that we had, I don't recall. After that, getting closer to what was his worry, it was more concerned about what is he going to do with the young lady in question, that she might be pregnant, and what is he going to do? He doesn't want to ruin his family or mess up what he has already going on.
All right. Did he in fact tell you she was pregnant?
Yes.
Did he tell you who she was to him?
Yeah, his wife's niece.
Did he use her name to you?
Not that I can recall. It's mostly in that term.
When he told you that she was pregnant.
After a short break, we will get you back into court in the pregnant niece murder trial, where the defendant's brother is still on the stand. Key testimony in this case. Stay tuned.
Yeah, he
Shopify point of sale makes it easy to start and grow your retail business.
Yeah,
tonight on closing arguments, diving deeper into the Delphi.
Yeah, he didn't want to testify against his brother. That's Linda boyfriend. Linda over him flirting with that man. Michelle gonna get you. Yeah, he oops. Oh, I gotta put out because Michelle, you know what? Yeah, he didn't want to do that. He didn't want to tell on his brother. He didn't. He it's something going on with him. It's something happened to them too. That's how he act. I don't know. Look like they kind of let it. I don't know. Seem like they ain't got no sense. Cause he said him and his brother, they're like they don't get along. Luna over here flirting with him. He married Luna with 8 children. Yeah, he really was. He got 8 children, Linda. Of course not. He loves his brother, but he just doing what's right. Yeah, he doing exactly what's right. And see, and that's why they don't get along, because they get along, but that's why they don't get along sometimes, because what his name, Johnathan, always doing something, and then he have to straighten it out. No telling how many times Johnathan done did something and he got to straighten it out. I wonder who else the state y'all gonna bring up. I was trying to look for the detective with the dogs. Cause we got to put some strain on this case. I do too. The Brady Bunch. London what the Brady Bunch. The Brady Bunch. Girl, you man. She want that Brady Bunch. You a miss. Girl, you a miss. I'm glad they sentenced Henry. When they oh yeah. Shoot, Henry think ain't no joke, boy. Henry gonna tear up that jail. I think the mother and the sister and the aunt. Oh, you think they gonna call the mother? I don't think they gonna call their mama back up there. Yeah, the judge said 10:30. But I'm talking about in this case right here, we were trying to see who they gonna bring back up there. It's Andrea. That was going. Andrea ain't going on jail. They ain't sending Andrea to jail. Hannah drove that girl crazy. Hell, sitting over there in that corner. She ain't going. Now, when he have his sentencing, it may be when they supposed to send him. They said something October the 1st. Now, with this case, I wonder they gonna bring her mom, Ayana mama, like she don't know who they are, but she act like she don't play though. Girl. I don't want to talk about Henry Dinkins. Not right now, baby. Let me focus on Johnathan. Cause Henry will give you the headache. When I figure out it's right there. Okay, London. Go up there. Go all the way down to the right where it said at the top where you see community and all of that. Video, shorts. Oh, you ain't gonna be able to do it on your phone. You have to do it on your laptop.
Creating your will or trust with LegalZoom is fast and affordable, making it easy to protect what matters most. Plus, you get
Cause Michelle had to do it on her laptop. We ain't think about 4XL right now. 4XL ain't giving me no headache no more. He's something else. We trying to get Johnathan. Let us get Johnathan out the way first. Ooh-wee. I ain't never been that. Y'all know I used to be snoring right now. I ain't even did that since I ain't been no Henry Lincoln case. Gotta be her. Shoot, honey, Henry had me over him. No, ow! I ain't never slept like. I ain't never did slept like that. Henry had me exhausted. Him in that ponytail. I ain't never snored like that, y'all. Not I don't know. I don't think I have. But I ain't never went to sleep. I ain't sleep now. I'm not asleep now. Henry had me sleeping. Good God Almighty. Ooh-wee. I woke up, the commercial was on. Y'all were gone in communion. Y'all were gone and I'm still over here. Oh, boy, Henry had me going crazy, boy. I ain't never been that tired. Johnathan see him think everything funny. It ain't hit him yet that he getting ready to get life in prison. He's sitting up there looking at Michelle. He in there doing people toes and wiping. Ooh, wait. Ooh. Oh yeah, London, you ain't gonna be able to do it on your cell phone. You got to get on your laptop. That's why Big Dog can't do it. I don't think they're gonna get him to death penalty. London. I don't think they're gonna get him to death penalty, y'all. These folks ain't work all morning. They just walking back and forth. That's Florida. State of Florida. London, you see it? You doing it? I use my TV and phone. It ain't gonna do it on your phone. And I don't have a laptop right now. I don't think you can do it on your I don't think you're gonna be able to do it on your TV. Mm-mm. 10:29, he gonna want to go on another break in 5 more minutes. We need to write him up. Henry got a ponytail. Henry, I don't know what Henry got in his hair. Oh, have y'all seen Tory Lane hair? I thought Tory was bald head. Tory don't grow some hair too. He ended up talking about oh Lord, honey. They need to cut their hair. They need to cut their hair. Wicks. What called what called Wick? Somebody what Henry got in his head? And he need to take that mess out of his head. He don't got too old. But I'm turning 51 years old. Now he want to look like Superfly. They call it wig. Honey. Oh boy, it seems like I want to look like Superfly now. Linda says she like you you hair is Manny. He needs to shave it out. He need it. Oh my goodness. I don't know what's going on. What's going on? He got hair like that. Johnny think he cute. Johnny got plenty of hair to show up in there, don't they, y'all? They'll love Johnathan. Johnny, they gonna have to put him in segregation. Oh Lord. I almost look bad on Henry. Oh my goodness. You don't care, girl. Look, London like Joseph, y'all. the Brady. I don't know if y'all gonna be the Partridge family or the Brady Bunch. Y'all gonna be the Brady Bunch. Yeah, she like Joseph. I don't like neither one. I don't see nobody in that courtroom. Judge, if the judge cut his hair, me and him will be all right. That little piece he got on the side, he can't be walking around me like that. It's just so weird looking at. I don't know who I want. Now, if Joseph sit his head up and speak, I like Joseph. I'd take Joseph from Linda. You know what? I love to cook. You like to cook, Linda? That's probably why I can't find nobody that don't cook. My man used to be the one to cook. I don't cook like that. I cook for me. I ain't no cooker like that. I'm gonna take Joseph from London. Joseph look like he take care of his wife, but it seemed like he got a look. I don't know, something off about their family. Something ain't right. Too much going on. Yeah, it's 10:30. Where they from? What? In Florida, they time the same as mine. I don't know what that judge doing. Yes, I bake from scratch. That's good. And cook my tail. Girl, we're gonna have to do a little cookout. We're gonna have to do something. You wait over there in somewhere else, honey. I know I ain't never been on no plane. That's good. Oh, that's what's going on. Yeah, London, he would love you to feed him and his 8 children. Yeah, he would love you. And then your 5 and his 8. Ooh-wee. Oh, you know how to make this? Rico right here. That girl is funny. You don't know where you I like the cook. Y'all like man. I can shoot. I like being around the y'all cause y'all like to cook. I don't like to cook. Mm-mm. Mm-mm. I tell a man to quitness, I don't cook. Connecticut. Oh Lord. I'm about to hang it up. Uh-huh. I know. He said 10:30. See, that's what I'm saying. They ain't work. Oh, they ain't work. And then I got to go to work. Tennessee. Please don't tell me you up there. Love that chicken from Popeyes. You ain't up there in Memphis, are you? You in Memphis, girl. Oh, okay. Y'all heard? Said I told y'all he is in CPT. You sure did. I heard you, but I'm the only one who heard. Oh, chat. This and him. Oh, Lord. Ooh. Yeah, I'm so curious about how the wife don't know what's going on. See, I'm gonna tell you who they might call back to the stand, y'all. They might call his wife back to the stand. Let me see. Good morning. They might call y'all, she said good morning. Y'all ain't said nothing. She from Madison, Wisconsin. Now he come off back there like Superman. Got on my nerves. They gonna report him. Hello.
I have counsel of state defense, Mr. Quiles present. How are we with the next statements?
Good news, Your Honor. We do have an agreement. And to make it simple, the state of Florida is asking to file a clean original copy of both, one of Paula Dixon and the other of SS. And I'm just for the record, it's DIXSON is how she has it spelled in her victim impact statement. And then, Judge, we'd like to make this a court-only composite exhibit for the clerk to then file right behind it the exact same thing with the defendant's objections. One, the objections are noted in red, and on the other, the objections are noted in highlighted yellow. What we've done, Your Honor, we'd like to file both sets of these to show, if needed, at a future date, the appellate court, what was objected to, and then the state has agreed to all the requested objections by the defense. So we have taken those out by providing a copy to each respective witness, blackened out of the exact same portions that were objected to. So then the record will reflect when they testify that what they'll read will actually match what has been objected to. So this time I'd like to file the first clean, it's 2 copies,
one copy of both victim impact statements.
Johnathan mad.
And the second will be both victim impact statements with the defense precedent objection. Of disagreement.
So are these being filed on the docket, or are these being taken for evidentiary purposes?
Just for purposes of the record to be filed with the clerk. We're not obviously asking them to go back with the jury with all the markings on them.
So I guess my question is, are they going to be filed to where you can go on the docket screen and see these statements, or are they being filed for identification purposes only to where they're essentially part of the evidence that will go to the appellate court?
Judge, just filed on the docket. Again, they're going to be reading this in open court, so we have no issues with it being filed on the docket.
Okay, so they're being filed on the docket.
Yes, sir. And then what the
Is there a better way to handle that?
Judge,
Maybe can they just be filed as for identification purposes for the appellate courts versus it being filed so there's public record on the docket now?
I have no objection to that if that's what the court requests, and there's no objection on stage.
Okay, so I can make them a court's exhibit. Obviously, if they're not my evidence, of course, but for purposes of just the evidentiary purposes, they're not filed on the public domain. They can be made as court's exhibits 1 and 2. We all know what they are. Everyone's agreeing to what they are. It's just for purposes of so they can be sent to the appellate court for review at a later date if that's necessary.
Yes, sir. The state agrees.
Defense agrees to that, Your Judge.
Okay, so we'll mark court exhibit 1 will be the ones that they're actually reading, and then a clean copy. Then count 2 will be, or court exhibit 2 will be the ones that have objections to it. Is that how you did it?
Yes, sir.
Oh, I saw. Is one court exhibit 1 is one witness, court exhibit 2 is the other witness?
Yes, sir.
Okay.
Court exhibit 1 is both victim impact statements unredacted.
Okay.
So the appellate court will have that on the record. And then the second court exhibit will be both victim impact statements with the defense requested objection.
Okay, you said it better than me.
Yes, sir.
And so to get to the end on this, the parties have agreed, or the state is conceding to the objections made by the defense on everything raised off both statements, and that'll be presented to the jury.
Yes, sir.
Okay. So at this point, are we ready to proceed?
Yes, sir.
You guys have seen the plenary instructions. I'll read to the jury with the state's aggravating factors and what's applying to counts 1 and 2. That's really the only thing that's necessary for me to insert in the plenary instructions compared to the final instructions.
Judge, we just have to renew our prior objection that we had raised earlier for purposes of stating specifically that we do not agree with the aggravator of the familial. I believe it was number 6 was the aggravator.
Correct.
We are objecting to that.
Okay. I don't think I asked the state for any position on that. Do you want to state anything more so than what the record already has on it?
No, sir. I think the court pointed out on the record with familial or custodial, being that he's in a relationship with her as her uncle, and with his belief that was his child and the motive for the killings. We believe this, particularly the facts, and I'll get into the facts and argument later today. But with all the things that I'm too time consuming now to go into, but with all the facts that bore out over the year and a half leading up to this, the state's position is that there certainly is a custodial relationship.
For scheduling purposes, I would probably get through openings and maybe the state's first 2 witnesses. The state will probably rest at that point. Probably take a lunch break then, and then I'll turn everything over to the defense, and then Zoom will be set up for you guys to use at your disposal.
Just so the court knows, our opening statement is brief. The defense has advised me that it's just 5 or 10 minutes, and the victim impact statements will be 15, 20 minutes, both reading them. So if the court wants to keep going, we're at the court's pleasure, but we will rest at that point.
After they arrest, we could probably get through Dr. Rohr before lunch.
Do I need to dismiss the jury for any motion practice after the state's case?
Man, they doing too much.
Okay.
Look at Johnathan.
Any reason why I can't bring the jury in?
No, Your Honor.
Defense?
They are.
All right, let's bring the jury in, please.
Your Honor, the jurors are entering the court.
Members of the jury, welcome back. You guys may have a seat. Does everyone have their notepads? Okay. All right. Well, good morning, everybody. It's good to see everybody. Hope you had a nice weekend. We're going to go ahead and get started. I have some instructions to read to you guys before we get started. Members of the jury, the defendant has been found guilty of 2 counts of first-degree murder in a previous proceeding. The only issue before you now is to determine the appropriate penalty. The penalty for each of these crimes is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the attorneys say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you have heard during the guilt phase of the trial, is presented to you to determine whether the state has proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case are as follows. The following aggravating factors apply to both counts 1 and 2 unless otherwise noted. Johnathan Quiles was previously convicted of a felony involving the use or threat of violence to another person. The crime of sexual battery is a felony involving the use or threat of violence to another person. 2, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. 3, the first-degree murder was especially heinous, atrocious, or cruel. This aggravating factor only applies to count 1. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily tortious to IS. 4. The first degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the crime of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. The unborn child of IS was a person less than 12 years of age. That's for number 5. This only applies to count 2. Number 6. IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over IS. This applies to count 1. The unborn child of IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over the unborn child of IS. This applies to count 2. Once the state has presented evidence of the existing of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law. After the final instructions are given, the alternate jurors will be released and you will begin your deliberations. You should not form any definite or fixed opinion until you have heard all the evidence, the argument of the lawyers, and my instructions on the law. Until that time, you should not discuss this case among yourselves. Your decision must be based solely on the evidence or lack of evidence and the law. During the penalty phase, the court will take breaks and you are permitted to separate and go about your personal affairs. During these breaks, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you're on the jury and ask that person to stop. If that person persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during breaks, but even then you must not use your devices to find out information about the case or communicate with anyone about the case or the people and places involved. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each breaks, please double check to make sure your cell phone or device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The penalty phase must be tried by you only on the evidence presented in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, internet, an electronic device, or any other means at all to get information related to this case or the people and places involved. This implies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned or use the internet to look at maps or pictures to see any place discussed during the penalty phase. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family members make comments to you or ask questions about the penalty phase. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about the case by using an electronic device. You must not use phones, computers, or other devices to communicate. Do not send or accept any messages related to this case or about your jury service. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, and make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence presented. Any independent investigation by a juror unfairly and improperly prevents the parties from having the opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as jail time, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. In the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence. And the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. It is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. It may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will take. When such conferences occur, they will be conducted to consume as little of your time as is necessary. We'll begin with our opening statements, and State, you have the floor.
Please the floor.
Yes, ma'am.
Good morning, ladies and gentlemen of the jury. The state of Florida thanks you all for your time and attention that you have given the past 2 weeks, and including the verdicts. Johnathan Quiles is now a 2-time convicted murderer and a convicted sexual batterer. Each of you know the horrendous facts that occurred in this case back in December of 2018. Each of you know why the defendant killed IS. Each of you know why the defendant killed IS's unborn child. Each of you know how the defendant killed IS and her unborn child. You all know about the ongoing sexual abuse that the defendant did of IS in the late 2017 going through 2018. Each of you did justice when you convicted the defendant beyond a reasonable doubt of premeditated murder of IS and the premeditated murder of IS's unborn child. Phase 2, though, ladies and gentlemen, is about fully holding the defendant accountable for each of his actions that led to why we are here today. State will rely on the evidence that you all heard during those 6 days in phase 1. We will now commence phase 2, which will be the weighing process. And Mr. Skinner discussed this during, if you can recall, 2 weeks ago during jury selection, going into that second and third day. Now, the first thing that will be asked of each of you is if the state has proven beyond a reasonable doubt the alleged aggravating factor. Now, we have alleged 5 different ones for each murder. However, there are 4 in common that will be applicable to the premeditated murder of IS and her unborn child. And then there is a different one that will be applicable to IS and a different one that will be applicable to only the unborn child of IS. Now, if each of you find unanimously, beyond a reasonable doubt, that at least one of these aggravated factors we have proven, then you can move on to the second step. And that second step is where you weigh and whether the aggravating factor is proven is sufficient. If you find that the aggravated factor is then sufficient, you then will move on to the third and final step, which is whether the aggravating factor outweighs any mitigating circumstance provided by the defense, and that has been proven by the greater weight of the evidence. Now, again, as the fact finder, as the juror, you can determine if that weight is great, medium, slight, or holds no weight. That is, again, your right, your choice as a fact finder, as a juror in this case. Now, an aggravating factor, it increases the gravity of the crime or the harm to the victim beyond the harm inherent in every first-degree murder. And again, you will hear victim impact evidence. However, this is only to demonstrate the victim's uniqueness as an individual and the loss to the community of the victim's death. However, victim impact evidence must not be considered by you when weighing each and every aggravated factor that state of Florida has alleged. The aggravating factors, I'm just going to cite a couple of points and then move on, ladies and gentlemen. The first one is that Johnathan Quiles was previously convicted of a felony involving the use or threat of violence to another person. And keep in mind, the crime of sexual battery is a use or threat of violence to another person, just like each murder is. So if you all think about it and count 3 of the indictment, previously, because we have heard that he was convicted of sexual battery. He was convicted of 2 counts of murder. So in thinking about IS, that previous felony, because the defendant is now a convicted 2-time murderer and sexual battery, you can use that sexual battery, or you all could use the murder of the unborn child of IS. 4, when weighing whether or not the murder of IS. Then when thinking about the unborn child of IS, You can weigh that again, count 3, the sexual battery, and also you can then also weigh the murder of IS for count 2. And just thinking again about SS witnessing the incident about a year ago at that 1503 16th Street. The DNA results from March of 2018 regarding the sexual battery, and the IS was staying the night with the defendant during the weekend of July 7th, 2018, and that she was pregnant over 5 months at that time. The long drives, as we had heard evidence from you submit, that you had heard evidence involving the Trout River location and the defendant's van. And again, lastly, the defendant's statements and confession to the wire, which is state's evidence 66. Been about a year the defendant had stated, or maybe less than a year. And it had been about a month prior to the last time the IS had sex, given the fact too that the sexual battery had occurred and had been occurring prior to December 19th and 20th of 2018. The next one for consideration that's alleged aggravating factor by the state of Florida. The first degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Well, again, we have heard that the defendant, even with the thought we submit that it was his child, it didn't even have to be his child for the defendant to have committed murder on the unborn child of IS or of the murder of IS. In fact, in State 66 in the wire, quote, as she had gave birth to that baby, I've been sitting right here with y'all. She was killed to avoid sexual battery charges, and the unborn child was killed to avoid sexual battery charges. Next alleged aggravating factor by the state of Florida was that the first degree murder was especially heinous, especially atrocious, or especially cruel. So I like to point out it's an or. State of Florida does not have to prove all 3 by a reasonable doubt, but we do have to prove one of those by a reasonable doubt. And Your Honor will go over what those definitions are again later today. And again, in thinking about those terms, what we heard during the evidence in phase 1, again, the IS was 5 months pregnant between December 19th and 20th, 2018. The defendant stated that after he falsely lured her to his employment at Ace Pickup Parts, that they would run away. He strangled her, but he could not stomach it. Basically as a way to kill her. So eventually shot her in the chest and the heart. And again, we had heard this from the confession of witness testimony of Joseph Quiles, the brother. Next, the alleged factor by the state of Florida that we intend to prove beyond a reasonable doubt. The first degree murder was committed in a cold, calculated, now this is an and, so we have to prove all 3, premeditated manner, without any pretense of moral or legal justification. Again, in thinking about count 1 and 2, thinking about cold, we submit and recall the evidence to you all regarding what Naomi Mobley stated. After IS went missing, he slept like a baby. Also, too, in hearing from Joseph Quiles and what he had stated during his messaging with the defendant back in December of 2018, he talked about the defendant's selfishness as well. Calculated that the defendant planned the murder of IS and her unborn child for months, as we heard from Joseph Quiles during the evidence of phase 1. Again, about the lured to his work false pretenses, turning off the phone location of the defendant, IS turning off her phone location data. Having IS in a remote area of Ace Pickup Park. The defendant having access to vehicles, a firearm, a forklift, the knowledge of the container and how it would go weekly, getting duct tape, having bags, and then afterwards going to the gun range. Defendant knew in August, as we heard again through evidence through phase 1, the IS was pregnant based upon those Snapchat messages and states evidence 63 and 64 as early as August of 2018. IS did not want an abortion. We also heard from the evidence during the case that her family members did not want her to have an abortion. Ms. Mobley had stated she found out on December 3rd, 2018. Ms. Naomi Mobley stated that the rest of the family found out on December 6, 2018 during her testimony. And we all know that the pregnancy was confirmed by Dr. Achu on December 13, 2018. The pressure was on the defendant. We also heard from Naomi Mobley regarding his actions, his nervousness, fidgety, something was bothering him, and that he knew the consequences, as stated in The Wire as well. Sitting right here with y'all, again, as she had given birth to that child. So we submit the evidence will show that we have proven cold, calculated, and premeditated. The unborn child of IS was a person less than 12 years of age. This is only applicable and alleged to count 2 involving the unborn child of IS. You've heard testimony again that she was 5 months pregnant on 12/13/18 by Dr. Achu. You have seen a picture of IS, which was states 23, where she was pregnant. And you all have also seen states evidence 24, which is a picture of the sonogram that Dr. Achu performed. That in fact, we feel comfortable that you all will find beyond a reasonable doubt that we have proven this aggravating factor that IS's unborn child was less than 12 years of age on December 19th through 20th, 2018. Lastly, IS and her unborn child of IS was particularly vulnerable because Johnathan Quiles stood in a familial or custodial authority over IS or IS's unborn child of IS. So first, in just thinking about IS, I would submit and bring your attention to count 3 of the indictment during phase 1. One of the elements the state of Florida had to prove beyond a reasonable doubt was in fact that Johnathan Quiles was in a familial or custodial authority over IS. You all have already found that to be beyond a reasonable doubt. You all have already heard testimony by multiple state witnesses that the defendant was in fact her uncle. IS was over the home. He would teach her how to drive, teach her how to swim, and that Naomi Quiles, the aunt, would not be there, and Miss Kim Mobley would be at work.
It's now easier than ever to find affordable health insurance in Georgia. Visit georgiaaccess.gov.
Your attention to the testimony provided in the Snapchat messages and then combined with the testimony of Naomi Mobley. When the fact is, well, again, and coupled with the information that we already know, that the defendant discussed about eating and making sure that she got enough food for the baby, as we had read in those Snapchat messages, as Ms. Mobley had indicated, the defendant was doing the same thing for IS as the defendant was doing for Naomi Mobley because she was also pregnant at the same time. So ladies and gentlemen, at the conclusion of phase 2, the state will have proven beyond a reasonable doubt each aggravating factor that we have alleged. We will ask you all to then find that the weight, that they are again substantial, and that the weight of the mitigating circumstances that the defense will provide will not outweigh each aggravating factor beyond a reasonable doubt, and will ask you all to render a vote of death. Thank you all for your time and attention.
Yes, sir. There's a microphone for you if you need one as well.
Thank you, Your Honor. Good morning, ladies and gentlemen. Again, we stand before you today. We are asking you to listen to the facts of this. We've heard your verdict, and we are asking you to weigh the life of Johnathan Quiles. In doing this, we want you to keep in mind that Johnathan Quiles, although you have found him guilty of this act, does have certain redeeming factors. In doing this, we intend to show and bring forward several of his family members, as well as a psychologist, Dr. Jennifer Rohr. You will hear from his family that Johnathan Quiles was raised by his mother almost exclusively, as his father was not in his life. You will also, we believe the testimony you're going to hear today is that until you found him guilty, he had no prior criminal, any other criminal offenses. Johnathan Quiles was 33 at the time of this incident, of which you found him guilty of. Prior to that, he did use drugs and alcohol, mainly marijuana, but when he was a younger child, of which he was engaged in another sexual relationship at a young age, and as such, he quit school at a young age at 15. Since that time, he had 5 children. Up until his arrest, he was raising those children, taking care of all of them, and worked very hard. You're going to hear from both his aunts, his uncles, and his family members as to the type of person Johnathan Quiles is and will continue to be. Now, the state has brought up the aggravators. Again, ladies and gentlemen, you must find him or find those aggravators unanimously. In going through our mitigators that we intend to present, you only need to find a mitigator will outweigh their aggravator in order to find for life in prison. And each one of you can hold that individually. This is not a collective group. You can find your mitigators outweigh their aggravators, and in doing so, you can stand by and hold your abiding belief that death is not the only option. In doing so, the mitigators, again, more of which you will hear through the course of the day, we believe you're going to hear that since his arrest, that Johnathan Quiles has become a trustee at the jail, which is unheard of for somebody who has been accused of a crime of this nature. Not only is he a trustee, he has taken up religion. He reads the Bible to other inmates. He does and has provided to the elderly and the infirmed in the jail and takes care of them. And we believe that the testimony you're going to hear from Dr. Rohr is that although you have found him guilty of this, he can flourish in a controlled setting and provide to those others as such. That in and of itself, we believe, as you hear these mitigating factors, can and should outweigh the death penalty. Life is always an option. He can be a productive member in a controlled setting and in this facility and provide to others who need assistance. Johnathan Quiles, although he is in jail, has no cognitive or neuropsychological deficits.
You've heard from his brother who testified here today through the course of the trial. You will hear from him again today as to why you should consider sparing his life and giving him life. The same person who testified in the guilt phase will testify again here in the penalty phase. Again, you will hear that Johnathan Quiles does have a loving relationship with his 5 children. And again, he's a dedicated and hard worker, and that since his arrest, he has no disciplinary reports. He has not gone out and sought more problems, more trouble. He is not fighting in the jail or creating or committing new crimes. That is, again, significant in and of itself. For somebody who's alleged to have committed a crime of murder and sexual battery, he is not going out seeking out new crimes or committing new crimes. At the end of the day, again, ladies and gentlemen, you are the trier of fact. Listen to the aggravators, listen to the mitigators, and keep in mind, one mitigator alone can outweigh their aggravators in your contemplation of sparing Johnathan Quiles' life. And at the conclusion of our testimony, we hope and believe that you come back with that of life in prison. Thank you.
Thank you, Mr. Davis. State, you can call your first witness.
You're on the state with the first call, Paula Dixon.
Ms. French, I'm going to read the jury an instruction once Ms. Dixon's sworn in.
Yes, sir, Your Honor.
Ms. Dixon, good morning to you, ma'am. Just come over here to your right. Watch your step as you come forth. Need a glass of water or something, let us know. We're able to certainly get you a glass of water. You can address the microphone as you deem necessary, okay? Thanks. All right. Yes, ma'am. Members of the jury, I mentioned this to you in my preliminary instructions to you. I'm going to read it again, given the witness.
Oh, my God.
The state's now going to present in victim impact evidence to you. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. Ms. French, you may inquire.
Thank you, Your Honor. Good morning.
Good morning.
Please introduce yourself to the jury.
My name is Paula Dixon.
And spell your last name, please.
Dixson.
And ma'am, are you related to IS?
Yes, I am.
And how?
I'm her aunt.
And are you Kim Mobley's sister?
Yes.
And Ms. Dixon, did you provide a victim impact evidence statement?
Yes, I did.
And would you please read verbatim your victim impact statement, ma'am? And take your time.
Absolutely. Your Honorable Court, my name is Paula Dixon, and to the family, it was no secret that I was Ayanna Sawyer's favorite aunt. I remember the day she was born like it was yesterday. I received a call advising me that my sister had gone into labor. My husband and the guy, I gathered our children and met my mom and my sister at the hospital. After hours of labor, Ayanna Michelle Sawyer made her grand entrance into the world, and it was love at first sight. My Princess Yana Boo was the perfect baby. Her smile was so contagious. This was my sister's first child, so she did everything by the book. I literally watched her embrace her new role as a mother. We had our first birthday party at my house, which I will never forget. I said, Yaya, what do you want to eat? She pointed to the plate and said, beans. We pulled out the smash cake, and she sat on my lap as I fed her. My sister came up with the bright idea to push her face in the cake, which I simply refused to do. Instead, I took her hand and stuck it in the cake. She turned to me, held out her hand, and said, "It's dirty." It tickled me something serious. Shortly thereafter, Maya was born. My sister couldn't wait for her daughters to finally meet. My two nieces were inseparable from that moment on. My mother raised us to always be there for your sisters, and I can see that my sister was ensuring that our next generation would do the same. In years to come, she would gain two additional brothers. Being the oldest, she became a natural-born leader. She would teach her younger siblings how to read, write, do math, and a plethora of other things. She utilized the leadership skills that she gained at home to pursue other endeavors at school. She was an honor roll student, a crossing guard, and a great friend, to name a few things. She was the definition of, if I can believe it, I can achieve it. She never let a challenge stop her because she knew she could do or be anything she put her mind to. At an early age, we saw that she strived to be the very best and that she always wanted to be a top performer. As a family, we encouraged her to never settle for less because we knew she was destined for greatness. She began receiving scholarships when she was in elementary school, and by the time she entered middle school, she was in honors classes. She began doing extracurricular activities such as playing the violin and joining the step team. As she entered high school, she began taking college courses and was on track to graduate early. She loved to dance and had the craziest sense of humor. One time she called out to one of her brothers, telling him that she needed help. He came running in to see what was wrong, and as soon as he hit the kitchen floor, boom, he slipped and fell on the dishwashing liquor that she put all over the floor. She got a good laugh off of that one. This is just one of the many jokes she played on her siblings. She was the best big sister and very big on family. She was truly her mom's little mini-me. Her siblings looked up to her. As time went on, she became a big cousin. The babies just loved her. My nephew was so crazy about her. One time she was sitting at the top of the stairs and he began climbing up the stairs to get to her. He made it about halfway and said, "Ya." I guess it made her heart melt because when she went down the stairs to pick him up, she was such a diva and a true fashionista. I started getting her lotions and fragrances from Victoria's Secrets, and she immediately fell in love with the pink line. She knew that for her birthdays and Christmas, she was getting something pertaining to pink. The smile on her face when she opened her gifts was priceless. She loved to eat. We would have family gatherings regularly, from seafood Saturday to Sunday dinner. Thanksgiving was one of her favorite holidays. I started a tradition letting the kids spend the night so they could help prepare the meal. She loved being around family. Her smile lit up any room that she entered, and she was such a joy to be around. She was our princess, and she wore the title well. As time passed, we received shocking news that she was pregnant. I was so excited to be a great aunt, and I could not wait to find out what she was having. It was almost Christmas time, so I made a big Sunday dinner, and everyone came to my house to paint nutcrackers. I guess the baby liked the greens because she started moving around, and I said, "Uh-oh, the baby's gonna like my cooking." Never in a million years did I imagine this would be the last time that I saw her. The following Wednesday, I received word that she didn't come home from school. I can never put into words the feeling of panic that came over me. From that moment on, our lives would never be the same. We called and texted her for weeks with no response. After a while, we received the news that no one wanted to hear. She was gone and never coming back. We had to tell our children that she was gone while holding back our tears as we wiped theirs away. My poor sister had to keep herself together because she had 3 other kids looking to her for comfort. Their sister was gone. I can only imagine how my niece felt having to look at an empty bed day in and day out. My poor nephew struggled to cope with the fact that she was never coming back. I watched my sister stand still for almost 5 years. Her baby and grandbaby were gone without a trace. All the sleepless nights, the tears, the pain of not being able to give them a proper home going, the family dysfunction. This tore our family apart. I had to sit back and watch my sister try to make it from one second to the next. There were no words of comfort we could offer. All we could do was be there. I had to take time off from work to try to get my mind right. Sometimes all I could do was cry. I had to hold on to my faith because that was my baby. I will never forget the many nights that I had to comfort my child. We were at an all-time low. I watched my family completely fall apart over the years. There were so many ups and downs. This loss left a hole in our hearts that can never be filled. How do we move forward as a family? We kept our faith and awaited our day in court. I sat in the courtroom every day and watched my family testify one by one. My heart broke all over again. It was not all for nothing. Justice was served. But how do we pick up the pieces knowing what we know now? We will never truly heal. How can we? Grace and mercy has carried us thus far, and we must hold on to his word. There are so many things we will never be able to do. We will never be able to meet Hazel, never get to see our princess as a mother. We will never see her go off to college. We will never see her get married. We will never see how great she would have truly been. We will never get to see her live. Now we are left with memories, a bunch of what ifs. What must live? We must live the remainder of our lives with a bunch of regrets, but because we can never turn back the hands of time. We must live with a constant reminder that our princess is gone. We must live with the guilt of knowing that even though we were our sister's keeper, she is no longer with us. That's a burden I wouldn't wish on my worst enemy. We must now figure out how to proceed as a family going forward. How do we heal? How do we trust? How do we live given all that we've learned? The only answer I could come up with is by the grace of God. I know that my God is a faithful God. He will never leave us or forsake us, and he will never put more on us than we can bear. Justice is just the beginning of our healing process. We must now learn how to live with the unimaginable loss that we have suffered. I know our princess is still with us every time we see a rainbow, pink skies, or a red cardinal. We know she is there. I thank God for the 16 years that he allowed us to be in her presence. The world will never know how great she really was or could have been. She will live in our hearts forever. I like to think of her as an angel that my God called home. He needed her more than we did. The flesh wants us to hold on forever, but that's human nature. To my Yana boo, I love you unconditionally. You will take it from us too soon, but we will continue to honor your memory until we meet again. You are loved, and we miss you so much. If he brings you to it, he will bring you through it. I love you unconditionally. I don't know how, but we will get through this. Long live Princess Yaya and Princess Hazel. Thank you.
Nothing further, Your Honor. No question. Sure.
Yes, ma'am.
Thank
Mm. Woo. Chad, I know this is. Judge felt that, y'all.
State.
Yes, sir, Your Honor. The state would like to next call SS.
Oh, they call her back. He sure was.
Kim, good morning. Watch your step. If you need a glass of water, let Mr. Gray know. Certainly accommodate you. Statement inquiry ready.
You just please reintroduce yourself to the jury.
Samaya Sawyer.
And are you the sister of Ayanna Sawyer?
Yes.
And did you provide a victim impact evidence statement?
Yes.
And Ms. Sawyer, will you please read it verbatim to the jury?
Yes. From now until the day I perish, there will always be an element of my life that will be permanently missing. That element is Ayanna Sawyer. Our lives were so intertwined, everywhere we went, we were asked if we were twins. In fact, you would rarely see one Sawyer sister without the other. However, now you would never see me or my sister together. Ayanna was my older little sister. She was so childish she could make you laugh at the most inappropriate times. But that's what made her so special. She was the beam of sunlight that could peek through a hurricane. We could be grounded all weekend, and yet she would still make it feel like it was a normal day. Ayanna was extremely intelligent. She wanted to be a pediatrician. We planned on going to college and becoming physicians together. We planned our lives around each other so much, we even decided that each of us would live on opposite sides of the riverwalk with apartments facing each other. Unfortunately now, I'm completing those same milestones by myself, with every accomplishment bringing great sadness. For every congratulations, the thought that I should not be my mother's first child to graduate, attend college, or move into an apartment crosses my mind. It's extremely difficult to step into my childhood bedroom and see one bed where there used to be two. Every loving memory that I have of my sister has always been overshadowed by the fact that memories will be all that I can carry with me in life. I'm always saddened by the fact that I will never be able to hear her voice, argue over whose shirts is whose, know her daughter Hazel, or see the beautiful woman and mother she would have become. After the announcement of my sister's disappearance and death, school became another place of torment for me. Every day, people I have never met, who I have never seen before, would approach me and ask if that dead girl was my sister. There would be times where I would randomly have to leave school to go downtown to the police station. There were so many occasions where there was little to no notice, and most instances I would be there late into the night. Still, even that did not compare to the misery I endured within those school walls. There would be days where I could not fathom the thought of walking through school doors. On those days, I would sit in the car until the end of the school day and just cry. However, when the 2 o'clock bell rang, I had to compose myself as if I was not in disarray, so my younger brother did not see the mental instability the situation has forced upon me. As I now have to be their source of comfort, just as Ayanna was for me. On numerous occasions, the dismissal process from school would be a battle in itself, as media stations would linger to report their stories on my sister's disappearance. Throughout the time Ayanna has been gone, day by day, individuals have questioned my mother's parenting. It's very difficult as a teenager to see those who have only read about my mother's question how she raised my siblings and I. Might I add, my mother was and is still an exceptional mother. I remember nights seeing my mother crying on her closet floor, blaming herself for Ayanna's devastating loss. There's nothing that I can do ever to lift that burden from my mother, but assure her that it was not her hands that caused Ayanna to no longer walk this earth with us. As if it was yesterday, there will always be an image ingrained in my mind of my mother walking through the front door with bloodshot eyes. That was the night my brothers and I were informed of Ayanna's passing. Seeing my mother never agree to make sure that her children could grieve will forever weigh heavy on my heart. As I think about how my family has changed forever, I think about how my fiance would never meet the sister I speak so highly of. My sister would not have my sister will not be my bridesmaid at my wedding, or the fact that our future children will never be able to play together. My family will forever have an empty space that can never be filled by anything or anyone. Some nights I have vivid dreams of my sister, as if it was a normal day that we would spend together. But then I am forced to open my eyes and realize that it will only ever be a dream. All I can ever do is cry and wait for the day I will see her again. Then there are other nights where nightmares are endless. The disappearance of my sister has caused me a great deal of mental instability. I just can't understand how someone who is loved and carrying life herself can be thrown away as if they were trash, as if they meant absolutely nothing to anyone. Ayana was loved. Hazel was loved. Ayana was my compass whenever I felt lost. She was my best friend. There was a point where I could not fathom going through life without her, but I know she would not want me to be anything less than great in life. There's not a day where I don't miss her or cannot stop replaying her smile in my mind. What I would give to have just one more day with her. Even if we are arguing throughout the entire day, I would be extremely grateful. I never took into consideration the phrase, you never know what you have until it's gone. Until I was informed that Ayana will forever be gone, as it was then that I learned that half of me will forever be gone. Though she would never have a resting place, her loving memories will forever rest within my heart.
No further questions, Your Honor.
Nothing from the defense.
Good to see you again.
Thank you.
Anything further from the state?
No, Your Honor, state rise.
Defense. Representative Jerry, I'm going to take a 10-minute break real quick. We'll have an idea of what direction we're going thereafter. It's 11:40. Any longer? Okay, we'll come back at around 11:55. We'll go from there. The jury's outside our presence. You guys may have a seat. I still have counsel for the state defense. Mr. Quiles present. You just want to break?
We're ready to go. We were going to ask for a 5 minute, but I think a little bit longer. That's no problem at all. But we're ready to go. Dr. Roars, and I'm prepared to be called.
It's already almost 12 o'clock. How long is Dr. Roar going to be? Just so I know for the jury's sake. I'm happy to go ahead and give the jury a lunch break now and just tell them, go ahead and go to lunch. See you back at 12:45. Just so you guys know, my plan would be at this point, have you finish your case. If I'm assuming you can finish it this afternoon, we'll see how long it takes, and then just do closings tomorrow morning.
And Judge, just from our perspective, we would be prepared to do everything today. I do not expect that it would take all afternoon to get through those character witnesses. I think if we could get Dr. Rohr done this morning before they go to lunch, and then when they come back from lunch, I don't expect that those other witnesses would take longer than an hour and a half in total. That I just don't expect it to be there that long.
Okay, I don't want to send the jury out to lunch at 1 o'clock though. That's my only. I didn't tell them to be prepared for a late lunch. 1 o'clock is on the latter end. I'd rather just send them home now, or send them away for their lunch break now, and just this 5-10 minute breaks encompass in their lunch break, and we'll go forward this afternoon. Does the doctor have a conflict that's going to create a timing issue?
No, not at all, Judge. It's just we don't expect it to be lengthy.
How?
Bob estimates that his direct would be at max 30 minutes, and I know that the state might have a little bit to say, but I don't expect it to be longer than our direct by any means.
I'm fine with that court's proposed schedule.
just give them their lunch break now.
Well, yeah, I mean, they heard some powerful testimony. Let me give them a break.
Of course.
That may
There
be
you
the
go.
wisest thing to do. It's 11:45. I'll have the staff let them know that they'll have to 12:45 for lunch. So if that's 12:45. Let's say Dr. Roar's an hour. That's 1:45. You think we're closing by 4?
Judge, I would be shocked if we were not done well before that. I think that we'd be perfectly fine to do closings today. Spoken to the state about the length of theirs. I think both of our closings together would be an hour, maybe slightly longer for the state, depending on what he said. But so I think we could get it all done today, Judge.
All right, I'll make a judgment call at I'll make a judgment call this afternoon. I don't want them closing and being charged at.
He want to stay in the courtroom.
Understood, Judge.
That's my preference. They may have a different preference, but
State will be prepared for closing as well.
okay.
Yeah, whatever the court wants, Judge, we'll comply. We're ready for today. If we need to do it, and there's plenty of time. We're prepared to move forward.
Okay. And what I'll do is I'll have courthouse IT. So number one, please let the jury know they have till 12:45 for lunch. And then I'll have courthouse IT in here setting up the courtroom for Zoom purposes for your witnesses this afternoon. Just so you know, there's a camera on the evidence carts. That will essentially be your camera. The clerk will go over there, swear them in. That monitor, what you see on the evidence cart, will be on all of the devices in the courtroom. And the audio will be hooked up. So essentially, they're still using the audio in the courtroom, just like you do in first appearance court or like you do in a typical courtroom with Zoom nowadays. They recommended that would be the easiest process. And you have the Zoom ID, and I can control that up here as well.
Yes, Judge, and I've already provided the Zoom ID to the witnesses, the 3 witnesses that will be appearing via Zoom. And we did test, not on that Zoom number, of course, but on their devices. I've gone through that with them, so I'm hoping we have no issues today whatsoever. But
Okay, just give them a time that they can Zoom in, and we'll leave it up to you to make that time work. And I'll work if it fits in with your schedule or you want to move things around, whatever you want to do.
Yes, Judge. Now that we know the schedule as far as lunch, I will call them and make sure that we know that during this break here that they're available and try and get them on this afternoon.
Okay. Anything else we need to handle outside lunch? If we are going to closings today, I ask you to look at the final instructions. The one question I had stated is that part of the final instructions include if they put in a lack of record, I think he has a possession of marijuana charge. I'm not sure if you want that to rebut the lack of record, if that's worth it to you. Please take a look at that and let me know the state's desire. Everything else in the final instruction should be rather absent the mitigating circumstance, which I read, which I asked you to go over again to make sure that's the list in the order you want it. You don't want to combine anything or separate anything further out. Just take a look at it. I did it the way you guys proposed.
Man, right? Messed up my neck.
That way. Just take a look at that and we can discuss that. Maybe get here at 12:35 and we'll discuss those issues.
Yes, Judge. I think there's a way to consolidate just a little bit so it's a little clearer and not repetitive for several of them. So we'll do that over this break and make sure we have that to you. So we do plan to give you something additional from what you
do it over the break, or what you can do. What I would ask you to do maybe easier is copy and paste those mitigating circumstances into a separate Word document, work off that Word document, and then maybe email back to me over the break. Email it to me back after the break, and we'll take a look at it.
Yes, Judge, we'll do that.
All right. See you guys at 12:35.
Thank you, Judge.
Well, 35. Well, y'all, what I do is come back soon. I get out for work. I come back over here and set up and go on and get started, y'all. And y'all make me still at work. Cause I got to get ready. I'm gonna get ready to go in a minute. This so sad. This crazy, man. So what we'll do, ladies, we'll come back. What we'll do is we'll go ahead on and come back and see that the defense really wants to go on and get it. If you're gonna sentence the man, go on to sentence the man. The judge procrastinating now. He need to just go on. But yeah, I'm gonna see y'all. I should be home. I get out 2:40. 2:45. I should be here about 3:15. So y'all probably don't talk more to me. So soon I get home, I set up, okay? All right, ladies. Ladies. I'll see y'all. I'll see y'all when I come back, okay? Can I get one okay so I know y'all heard me? Can I get one okay, Michelle? Adula? Okay. All right. Thank you. Yeah, okay. They found her body in the room. And wait a minute. You said in your other case, they found about they ain't find that girl you talking about you ain't talking about wait a minute. What's the girl name, y'all, that we doing her case? We doing her Tamia Taylor? They not Tamia Taylor. Okay, baby. Risa, that's who you talking about, Tamia Taylor? No, they ain't found that girl. Yes, they did. What? They found oh my God, y'all. Oh my God, she was in the water. Oh my goodness. You know what? I got something ready to come out about her today. Or did I do it already? Man, are you serious? How'd she get there? How'd she get in Mississippi River, y'all? And she was in Memphis. Wow. I just did a live on her this month. Wait a minute. Hold up. I got one coming up on her. Okay, Brenda. Y'all know what? Hold up for a minute. Let me look at my don't tell me I just put it. See God working in a mysterious way. My mind was on that girl and I just did a upload on her because she was on my mind. And I said, why is this girl on my mind? Let me see. This is crazy. Let me see. Hold on for a minute. Hold on now. Hold on. Hold on. Girl, I got at 5 o'clock. I have a live I was gonna do on her. I said, where is the man who brought Tamia Taylor drink on the river? It's supposed to come on at 5 o'clock, and they don't found her. Ain't that crazy? I got it. You can go look at my channel now. I got it right there. She was on my mind. And I got it right there. Where is the man who brought Tamia Taylor drinks on the river, on the riverboat? That's the title. Well, I be a monkey uncle. Thanks for telling me that. Now I got to do it. Girl, wait a minute. You don't woke me up now. Hold up. I got to look that up. You don't woke me up. Hold on for a minute. No, no, that can't be true. Let me see. Hold on for a minute. I got to do this one, y'all. Hold on. Don't y'all go nowhere. Let me find this right quick. Golly, this is crazy. I was gonna come on at you supposed to come on at 5 o'clock. Thank you, baby. What? Oh, man. What? God, let me see. Let me see. Hold on, y'all. I'm freaking out now. I'm freaking out now. Cause I pulled a cat did her live at 5 o'clock at 5 o'clock today. And they don't found this baby. I'm so sick of this. I'm so sick of this mess. Let me see. Can I find? Wow. Update. And I was talking about her this morning. This is God working in a mysterious way. I don't see it right now. Why they ain't got it right now? Oh my God. 4 friends got on Mississippi and she got off. Oh Lord, y'all. Wait a minute. Hold on. Let me find the real news. I don't believe this. Thank you for telling me this. I don't see it though. Y'all, where is the news for it? The strange thing is that she was from the boat. I'm thinking they walked along the river and pushed her in. Oh my God, I can't find it. This, what was it on? I see somebody else found it. This lady right here found it. I can't play it. I can't play hers on my channel right now. I can't. I see she said found in Mississippi River. Wait a minute. Come on, y'all. Let me put it in there. Hold on. Let me see. This is crazy. She been on my mind. Body. Chicken. Oh man, here it go.
Are you sick of having issues with your webinars?
Oh my
Wasting
gosh.
troubleshooting with attendees?
That's not it right there, is it? This not it right here, is it? It's 13, 24, and 5. Let me see, what news is this? Is this it right here, y'all? Because they got a body found in Mississippi River. Man, I'm so mad. This got to be it. This got to be it. In Memphis.
Thanks for joining us on the news at 10. I'm Kevin McNamara. The discovery of a body on the Arkansas side of the Mississippi River this weekend has brought more pain. It's now been more than 2 weeks since Tamia Taylor disappeared. She boarded a Memphis riverboat for her 21st birthday and hasn't been seen since. Our Stephen Reels is here now to show us how authorities have provided little help to ease the family's suffering. Stephen?
Thanks, Kevin. Right behind me is around the area where several law enforcement agencies were called to yesterday. A body turned up near a piece of land owned by a company called Consolidated Grain and Barge. That's all authorities have said. No information was given about the person's race, age, or gender, only causing more worry for Taylor's family.
Until identification is done, we can't be sure of anything.
Saturday's body recovery announcement immediately had people asking, could this be Tamia Taylor? Could the body found just a couple miles downstream from the Memphis riverboat docks belong to the missing 21-year-old? Up until now, Memphis Riverboats has said there's no evidence Taylor went overboard, that she was last seen while the boat pulled into the harbor. But the lack of seemingly simple details about Saturday's deadly discovery has Taylor's family unable to talk publicly. So they're relying on a nonprofit that helps families of missing persons talk for them.
And everybody express themselves in a different way, but we just have to make sure that we're doing it the right way because it definitely can be harmful.
Jasmine Ellis says Taylor's mother first found out about Saturday's body discovery through a Facebook post. She heard rumors it might be a woman, but no agency confirmed that to her. So she remains hopeful. Through the Doc Ellis Foundation, Tamia's mother asked the community not to give up, as the individual retrieved Saturday has not been identified, but continue to pray either way. We may not know if it's Tamia, but it's someone's family member. The search must continue. So far tonight, the foundation says Taylor's family hasn't gotten any information other than the body was found, that they must wait for a medical examiner.
The identification of the remains has not been spoken on because right now they are in the, they're doing the autopsy report.
And with no identification, there's a stillness in the air as the family and the community wait for those autopsy results.
It's that awkward silence when everybody is at a standstill, hoping for the best.
Now, we did try to reach out to the Crittenden County Sheriff's Office.
Let me put it on this news right here that I started doing first.
A bombshell just in Crittenden County. Bria Jones, WREG News Channel.
Wow, I didn't even. When did it? Wait a minute. When did this come out? When did this come out, y'all? Hold on. When did this? Wait, y'all, this is crazy. Wow. Look, y'all. Let me let y'all see something. Let me let y'all see something. That little girl was on my mind yesterday, and I did a upload. I'm gonna show y'all. It's supposed to come on at 5. Hold on, man. She was on my mind, y'all. And I was talking about it, and I said, now how a 21-year-old get missing in her phone? See, let me let y'all see. Hold on right here. Let me see. This is crazy. I appreciate y'all even showing me that part. I ain't even seen none of this. Y'all done woke me up. Darn it. Y'all done woke me up. Yeah, but see, I got it up. It's supposed to come on today. There you go. I sure do. I got it coming on today. Tamia. She supposed to come on at 5 o'clock on my channel. Well, I be a monkey saying, I sure do. She supposed to come on at 5 o'clock, y'all. I have her. Let me put it right here. I have her coming on at 5 o'clock. Lord, see, when something be on your mind, she was on my mind because I wanted to talk to y'all about that. Because I was like, how a 21-year-old just going up and go missing and she got 2 kids. There you go. See, I got that coming on at 5. Where is the man who bought Tamia Taylor drinks on the riverboat? Well, I'd be a monkey uncle. And see, and what made me say that is, you remember the boy said the man bought her a drink. See, he bought her a drink and he gave her some money, but he saw all of that going on with Tamia. And said Tamia went to the store. Said she went to the bathroom. He showed that the boy who was with her watched her the whole time. Wow, this is crazy. Mine's still gonna come on. Mine's still gonna come on. She was on my mind yesterday. And I did it later on. I upload this for y'all so we could talk about it. And then y'all tell me this. Wow, this is crazy. Oh my gosh. I need to calm down. I gotta calm down. Whoa. That's her body, y'all. And her mama know it too. Oh my goodness. Y'all don't freak me out. Please tell us today. Please tell us today if that's the girl. Cause they shouldn't even brought that news out if that wasn't her or was her. They should have did it that way. Man, it's too much going on. It's crazy. And that boy gonna say, well, how she get in Mississippi River? How she get there? Cause the guy said she was walking with them, she was drunk. The man who was on that test scale said she was walking with them and she was drunk. She was with 2 girls and a guy. That was that text that little man said. Wow, y'all done woke me up. He sure did. He said they was walking, y'all don't freak me out now. Wow. That's Tamia body. Cause the Mississippi River runs into that. What's wrong with it? Hold on, guys. I got to see this again. I'm sorry. I would watch the news at 12. Yeah, watch that news at 12. Well, it's 12 now. Let me know. I'm gonna stay on here then. Oh man, this is crazy. And she was on my mind yesterday.
Our
Hold up. Wait a minute. You mean to tell me today Monday and they don't know about the body? Oh, it's 11 here. Okay. Today Monday. And they don't know who the body is on. It happened Saturday. They found the body Saturday and today Monday. Come on, they know her mama know it's her child. She have to know. Cause they found the body Saturday. And he hit him Monday. It don't take all night. Oh man. Man, they did that girl like that. Them two right, them three need to be investigated. Because I brought their name back up in that live right there. I brought that boy name back up. And he said that she was at the bar and a dude bought her something to drink. He watched her the whole time. Then he said he gave her some money. He could tell you everything about Tamia. And then he said, I had asked him where Tamia is. She was right here. Tamia got into it with somebody, y'all, at her house. At her house, she got into it with someone. Oh, they don't work on the weekend? God, they ought to have a stack of bodies then. It's just weird. And then she left her phone. She left her phone and went to use the bathroom, but she was standing right here. Something ain't right because that dude said she got off that boat. How did that girl get in that water? And they walked to her car. Cause he said, I wanted to get them a ride, and they told me no. Now at her house, it was what is that? Dispute. Somebody got into it, and the neighbor said that she walked down to his house and said she needed to talk to somebody. I wonder, did she get into it with somebody from the job? Or was it a man? I don't know. This is weird. But they need to investigate that boy again and them two girls. They got to find them. They got to find them, Abdul. They got to find that man, that boy who's on that trip. Talking about, yeah, this rumor's out saying that we did this. They need to find out. They need to investigate them three. Cause they was the last scene with her. Where did they take her? When they walked down there, where did they take her? When they got out that boat, where did they take that girl? Did they jump her? What did they do to her? And what was the purpose behind or whatever happened to her? Because he said it was them, him, and Shaquisha and somebody else. Then he said they met up with two more people. Now I wonder, is that the person? Did she have a dispute with from the party? Is it a baby daddy, baby mama with there at her part? It's something right, y'all. I tried to figure that out yesterday. I did a little while trying to figure that out. And then I uploaded because it made sense. I said, ain't no 21-year-old went missing. And I said, why are they trying to make it seem like a Kanika Jenkins thing? That's what I put in that video, too. I like, come on now. Wow. See, I'm woke now. It's time me to go out, get out of here at 12:30. If the news on, I do. The news should be on now. This is crazy. I'm so glad you came in here and told me that. Yeah, Lee, I just did. That girl was on my mind. That little child was on my mind yesterday. God, oh, she was on my mind for some reason. Whoa, God, that is crazy, y'all. Wow. And you remember that guy said, do you remember that guy, the man who picked people up, the taxi man? He said, oh, she walked through there. And she was saying she was intoxicated. And I asked them, did they want to ride? And they said, no, that's all right. They need to identify that driver need to identify that boy and them two girls. We have 30 minutes. Oh man, 30 minutes. Good God Almighty. Where you from? Oh, Tennessee. Yeah, y'all was funny. He said man. Y'all, it had to be them. It had to be that boy who worked with her and them two girls. Cause he said, the driver said it was a man, it was a boy and two women. And she was intoxicated. And I asked them, did they want me to drive her to her car? And they said, no, never mind. Why wouldn't they want that ride? Why wouldn't they want to ride? That been we'd be like, yeah, give me a ride. And then they say they met, then he gonna say they met up with somebody else. With 2 more other people. They don't jump that girl. Something happened on that job. It's a confusion against somebody. Don't get along with somebody on that job. And they was on that trip. And whatever happened at her house the day before she went on that trip could have been involved with what happened on that trip. See, some people, this remind me of Shaquetta Robinson. They got her down there and beat her up. And now they got what her name? Tamia. Now they got Tamia and I bet they jumped that girl. Why they do her like that? Why people killing folks like that? And threw her body over there in that water like it wasn't nothing. That what happened. Y'all don't woke me up, man. This don't trip me up. Oh my God. That's her body, y'all. That's her body. And they knew. See, what made that boy so nervous who was telling the story? What made that boy so nervous who was telling the story? He knew they did something to that girl. Or he knew who did what. He involved all them. Oh, wait. Oh, man. Police be on scooters, bikes. They just try to walk out of sight. My opinion, if it is her, it might be her. I'm glad y'all. Okay, if that's not her, her mama knows it's her body. Y'all, that's why her mama not talking to the news, y'all. They found a body Saturday, but y'all say they ain't working Saturday. I believe they worked on her body. I bet they worked. I bet they worked. I bet they worked Saturday. The reason why I said that is because they were looking for her. Oh man, y'all don't freak me out. Yeah. And she was on my mind yesterday, y'all. Yesterday evening. But this happened Saturday. This is crazy. In Mississippi, the Mississippi River run, y'all. That's that girl body. That's that girl body. Did I just see the riverboat? Well, hold on, yeah. Guess what? I bet, you know what, y'all?
The finding coming nearly.
You know what they did? They threw that girl body in that water. It made somebody else play her. And somebody else act like they were drunk. And that man thought it was Tamia. But Tamia was already in the water, or did they do something to her? Some of y'all. Now, if she was in that water, somebody on that boat would have seen it. Y'all know what I mean. I wonder. I know it's impossible. Wonder. Yeah, they could have been like we kept on saying that. Holla kept saying she could have been in that water, and one of them girls pretended like they were hurt, act like they was all drunk. That's why they didn't want to ride with the man. That's why they didn't want that ride, because they had already threw that girl in the water. You remember he said, maybe they threw her in the water. Somebody on the boat knows something. They already thrown that girl in the water. One of them girls done threw that girl in that water, probably, allegedly. And that body, that shit, they don't know where that boat be traveling from. They need cameras on that boat. What you mean by y'all? What that mean? Girl, the way these children are doing stuff, and they ain't even from there. She ain't from no Mississippi. I mean, said she ain't from Memphis. I ain't gonna even say nothing what nobody won't do. What system? I believe so. I believe that girl been in that water. And they played, they act like that was Talia or either Tamia or either they took us. What is a system, dude? What is a system? Cause you talking about young people now. That girl, somebody on her job, end up at that on that boat. Cause she had a disturbance. The police said they had a disturbance out there. She voted in the neighbor says they had a disturbance at the party, after the party. And I like a disturbance. Her co-worker was at her party, her family was at her party, and the neighbors at the party. The next day she walked down to the neighbor house and told her she needs somebody to talk to. Oh. What did the government got to do with this? Well, what did the government got to do with this? The government don't even know what happened. But we trying to get her off that boat. We trying to get how her body get in that water. This crazy.
2 weeks.
They did that. They did that. Them three, they need to investigate them three. They need to investigate those three. Yeah, I know what you said about the government. I'm trying to see what the government got to do with it. I just asking a question what the government got to do with it. I'm just saying, I'm trying to figure out how they got her. Cause the dude said that it was two girls and a man and to live. But that boy lying, he said two more other people came with them. Did they put her in her car and took advantage of her and threw her over there? Something. Come on now, y'all. Come on. Y'all don't work like that. Y'all know these kids. Damn, come on. She ain't for 21 years old. And they had to kill her. What made them kill her though? What made them? Man, throw her on over there in that boy. See, they see, you know what? I noticed something, y'all, and then I'm gonna let y'all go. Young people trust too much. They trust strangers too much. They trust is so powerful and strong with everybody else. I'm going to take this call to my patient after I can. Okay, thank you. They trust too. They trust so hard and they believe everybody else, but when the parents and somebody else telling them something, they don't want to believe them, but they'll believe somebody else. But y'all ain't gonna hold y'all up. I'm about to get ready to leave out. I'm about to leave out. Y'all done woke me up. Thank you, Reese, for bringing that in. I see y'all later, ladies. It ain't one thing, it's another.